Hello, I'm Russell Quirk, and I am here to talk to Aidan Loy, who is the lawyer for Contractors for Justice. You'll remember that name from recent property trade articles, no doubt, as the entity that is proposing to pursue the likes of Purplebricks and others with regard to a claim in relation to the self-employed status of their agents, their LPEs. So much publicised, but Contractors for Justice have asked me to talk to Aidan, who obviously is a clever lawyer type, with regard to trying to put some context, some meat on the bone to what is going on, what the case is about, and so on. So we thought it would be interesting to record it and to allow anyone that wants to, anyone that has an interest to watch and find out more. So Aidan, welcome.
Morning, Russell. Thank you very much. Glad to be here. Yeah,
no pleasure. Thanks for talking to me. So I want to ask a few questions about this proposed action. Obviously, it is a proposed action right now. Would you mind just kind of talking us through what the case, what the claim is that seems to have attracted so much attention? So lots and lots of attention from former and current Purplebricks, YOPA, LPEs, so local property experts and agents. So what is the case, and why do you think it has merit?
Well, it's the case doesn't actually stand on its own. It's one of, and people will know occasionally these things erupt onto the news on TV and the rest of it. But it's one of the long-running standard cases where organisations have attempted to reduce their costs by presenting legal fictions effectively that their employees are not employees. They're self-employed, or their agents, or another company employs them, and basically reduces their outgoings in terms of statutory payments to workers, such as sick pay and holiday pay and the rest of it. But these things have been tried for many, many years, and no doubt will be tried in the future. They all fail. People might remember recently, in the last couple of years, the case of Uber drivers who were claimed not to be employees of the company, and of course the Supreme Court finally said they were, and they were workers. And what we say, and what the people we've spoken to, who are our clients and potential clients, is actually they were employees of this company, and so therefore they haven't been paid holiday pay, they haven't been paid sick pay, there have been deductions made from their pay which shouldn't have been. And if someone's been working at an employer like this for several years, that's quite a tidy sum. The Uber drivers, for instance, only went back about 3 years, but the average win for all of those is around £30,000. And they were fairly low paid individuals.
So £30,000 per driver?
Yes, very much. Yes, indeed. So that's what it is. It's set against an honourable employment case like this, but this is effectively common law now. It's accepted in every single case that these people are employees, and the evidence we've gathered, both of the practices of the estate agents and the evidence provided by clients and potential clients, we think it's more or less a slam dunk. There's not going to be an effective legal defence of this, and in fact, there has been initial cases, and the only employment tribunal taken on this so far, the ex-Purplebricks employee won, and that's the standing precedent at the moment. So.
Just to be clear then, right, so obviously Contractors for Justice, so who you're working with, believed that there was huge merit to this case, this matter, but what you're saying is there's already a Purplebricks case, a precedent almost, if it is a precedent, whereby Purplebricks have lost a claim that rather helps you by the sound of it.
Yes, that's the case, and that hasn't been appealed. There are lots of others which may come forward, but whether or not that's necessary, we don't know. We'll see. But the law itself, as lawyers would say, is fairly trite at this stage, and we can't really see, and I certainly can't see, and I've been doing this for over 20 years, a potential successful defence by Purplebricks or anyone else employing this sort of model.
Yeah, and so to be clear, so your experience here is that you're a qualified employment lawyer of some years' experience.
Yes. I mean, well, all I've ever practiced is employment law and litigation. So that's what I do. I'm an expert in that. I've done that for 25 years. And this is one of a series of things which have been happening over the last few years. And we can see which way the wind is blowing. And it's fairly clear that if any ex-employee or current employee of one of these firms likes to join in this case, then it's pretty certain, although you can never say anything's absolutely certain in life, that they will win and they will obtain compensation.
Yeah, and look, it's certainly attracted, I mean, in the hundreds in terms of potential claimants, isn't it, by the Contractors for Justice?
Yes, at the moment. I mean, we have hundreds of people who are signed up and are joining with us. We can always welcome others, obviously. And the issue is effectively, as long as these individuals can produce sufficient evidence to show that they were or are working under one of these systems, so things like contracts of employment or invoices or bank statements or whatever, then they can easily join that. And if they don't have those things to hand, for instance, they can easily be obtained under data protection legislation. So that's not an issue. Really, the thing is, I think to a certain extent, it's getting the message out there. What we're talking about is a satisfied legal precedent built on a lot of previous cases in other areas, which are effectively exactly the same. And it looks like you will be remunerated and it won't cost you anything. So, it's probably one of the best offers you're ever going to get, certainly the best one since PPI, I suspect.
Well, it's kind of free money, isn't it? Because if Contractors for Justice are working on a contingency base, I think that there's a small, upfront cost that can be paid that mitigates the percentage cost in terms of the win fee, isn't there? But there's it's notwithstanding that, it's money that a Purplebricks LPE, either existing or previously, would not otherwise have had. So Contractors for Justice, you as the lawyer are going to do the work. It then is multiple claimants under one claim. I think you called it a group litigation order, don't you?
That's right, yes.
The correct term.
Yes, that's it. This will be done, as you say, on a contingency fee basis, but in the common parlance is no win, no fee. That's not how the law society describes it, but anyway. And yes, and so basically what we're doing is all the individuals we're talking about are in the same situation. The evidence they have to produce is effectively the same. So it's an organizational matter at the moment really to do this. And I say we're talking about not only in terms of other cases such as Uber, such as one earlier this month, at the beginning of this month, with Ryanair, which show exactly the same thing. We have an employment tribunal claim actually dealing with Purplebricks already. So legally, we're pushing at an open door. To be a part of this, people have to sign up and join up. Yeah. But it will cost them either very little or nothing. Yeah. So certainly if I was in this pool, I know what I'd be doing.
Yeah, and so let's talk about the stage that the case is at, because obviously, look, my PR agency, ProperPR, is the agency that kind of broke the news by way of a press release that this was happening. So that was a few months ago now. Some people may have sat back thinking, well, what's going on? I guess that the easy answer is that the legal process takes time. But can you put some flesh on the bone insofar as where the case is now? Obviously, now that you're involved.
Yeah, you're quite right. One can identify, these potential cases and claims, but going from that to actually ending up in court takes some time. As you say, if you're talking about rather than one individual, you talk about a group litigation matter, then you have to get the message out there, you have to attract people, we have to establish their bona fides, gather evidence and stuff. We're at that stage now. As you said, yes, we have hundreds of people who have signed up and joined up. And so we're now getting to the station. We're obviously still seeking anyone else who'd like to come on board, but now collating the information and evidence they've given us, such that they will all be listed and their claims quantified, which will have to be before being presented to court, or being presented to their former employer. Because in all of these things, we try and avoid litigation. We try and settle. So we'd be speaking to the other side, in this case, Purplebricks and other people, before we actually launch an action in court. Yeah. Because in something like this, if it is as it looks, and as I say, it is straightforward legally, then no one wants to waste additional hundreds of thousands of pounds in litigation. So we're trying to settle things first.
But Aidan, I guess people need to jump on, so that either those that have signed up and are yet to commit their evidence, so whether it's their bank statements, their invoices or whatever. So obviously if they don't do that, or if someone that hasn't yet signed up doesn't do so, presumably the door starts to close on the group litigation order, because you can't then just add people once that process has properly formally started, I guess.
Well, that's right. It's a question of judgment as to when do we effectively do that, because it would be nice to sit here and wait for everyone in the world to turn up, but some people won't for whatever reason, and we can deal with maybe that later on. But there has to become a point when we have to make a credible threat effectively with a sufficient number and go and say to the other side, look, here we are, guys, this is it. And so if there is anyone who is concerned for any reason, get in touch with Contractors for Justice, ask them. But it really is, as I have said, this is something which has no personal or financial risk involved. And if you're one of these people, you will gain from this.
Let's talk about that.
But you need to.
I'd like to talk in a second about, what potential reasons there would be for anyone hesitating over this, because I can't imagine that there are, but you may have come across one or two. So let's talk about those. But let's talk first of all, just to kind of set the scene a bit further. What do you think the size of this claim is, either for an average individual, and an average obviously covers all sorts of things, so that you'll have the LPE that did 6 months work and the territory owner that was there for 6 years, and there'll be huge differences in the
That's right.
of each individual claim. But can you give us a kind of sense of what each individual claim could be worth, and then therefore the enormity of the total claim? Because of course, when this was first publicised, this was published in the Financial Times, actually, as the first bit of media that broke this story a few months ago. There were all sorts of big numbers thrown around.
Well, I think that's right. I mean, as you said, there will be a huge variance depending upon how long someone's worked for, length of time, how productive they were. But for instance, the case I was talking about in the tribunal was between 30 and 50,000 pounds potentially. This individual believed he'd been.
Sorry, Aidan, this is the Purplebricks case that's already been heard. So that
Yes.
individual was into potentially a compensatory benefit of something between 30 and 50,000 pounds.
Yes, and he was not a particularly long-serving and not a particularly successful individual. So it's difficult to say. As you said, it varies around, but with the numbers we're seeing with the people we're dealing with, you would be talking in the round tens of millions of pounds in this thing.
Wow. And look, I have to say, look, I know this is not a matter for you as such, but the Purplebricks are kind of under the cosh and have been for some months. They've just lost their CEO. They just had an issue in terms of validating their next CEO, the one that they announced, that then took some time, shall we say, for the stock exchange to do their fit and proper person diligence. They've had all sorts of issues around their lettings operations and diligence and compliance there. They've posted some pretty horrendous numbers, actually, in terms of losses in recent months as well. So look, they're a beleaguered business, and I take no pleasure in saying that, but I'm just setting the scene.
Yep.
That you would imagine now, because they've been battered as much as they have over the last, 12 to 18 months or so, they'd be pretty keen for this to go away, wouldn't they?
Well, I mean, I think that's right. I mean, although I'm kind of a fan of John Grisham books, this is not what we're about. We're not trying to put a company out of business or destroy them. But I would imagine from their perspective right now, they've had a bad time for various reasons, being one over recent times. I would think this is a perfect opportunity for them to draw a line under this, and come to a sensible settlement without having to go to court. Because inevitably, when you end up in court and litigation, especially when you're talking about employment practices, no company wants to be seen as a bad employer. And we've seen very recently, it's an extreme case with P&O Ferries, and they have basically destroyed their company by their treatment of their workers. Yeah. And it's happened before.
Through the negative PR as a consequence of their actions and the way they've handled it. And I guess what you're saying is that, it's not in any company's interest, particularly if they are on the losing side of a case, but in the run-up to that case being heard, they're going to be further pushed and pulled and critiqued and lampooned maybe as a consequence of an ongoing legal case that they've chosen not to try and do something about to settle.
I think that's right. I mean, it's the reputational damage that a company is going to suffer because usually, inevitably, press coverage tends to focus on the sensational things, and if there's anything bad or looks bad, people do not like to see workers badly treated, and that potentially could reputationally be very, very harmful to Purplebricks or anyone else. And so I would think it's a perfect opportunity to bring this thing to a close. But I'm not on the board of Purplebricks.
No, and I guess that works both ways, actually, because Purplebricks are a consumer business, so this won't help their consumer reputation in terms of taking on new property listings, building revenue, but it also won't help in terms of recruitment of future LPEs, because I would imagine that those future members of staff, as they are now. So, of course, the other thing we should say is that Purplebricks a few months ago, of course, announced that after our action, the Contractors for Justice action began, that they were going to turn all of their so-called self-employed agents into employed agents. But regardless of that, yes.
Remarkable coincidence, I think.
Yes, isn't it? Yeah, isn't it? I'm sure those two things are not connected at all. So, but the fact that someone might be thinking about making a move into a state agency as a career, or maybe moving from Connells or LSL or whoever it might be, they're less likely to do that if there's this lingering case over the heads of Purplebricks, which kind of doesn't paint them in a great light, does it?
Well, I think that's right, and it's in particular, employment difficulties generally cause a great deal more reputational damage than other things. People, dislike companies who avoid tax or do this, that, and the other, but caring about someone who's been cheated out of money, and maybe someone brings it all home. So it can have a really long-lasting effect, as you said. It's something a company would wish to avoid, I would imagine.
Yeah. So it really importantly, I think the next bit, and probably the last bit of this segment, because I think you and I could talk all day about this. I'm sure people are fascinated by what's happening. It's clear that this is advancing. It's clear that there's huge appetite from the point of view of Purplebricks and other companies, former self-employed stroke employees, to jump on this. The door's closing, as we've kind of fleshed out, and this is not an infinite action that someone can just jump on in 6 months' time, let's say. So time is of the essence. So talk to me about the reasons that someone that worked at Purplebricks, or should we say worked with Purplebricks, let's say 2 or 3 years ago, for 2 or 3 years, what reasons could they possibly have for not jumping on this action and signing up with Contractors for Justice?
Well, I think there aren't really, but I think there are perceptions, especially perceptions about the legal process, which might put people off. I mean, one thing is, for instance, people think, oh, well, why would I need this company or a law firm to do it for me? As soon as it's settled in the courts, I'll simply put my claim in. Well, that might or might not work. There are still costs associated with that. But also, for instance, if this settles before going to court, then there's no precedent. And so you're left out if you've missed a bus. In terms of actually the court itself, I mean, some people we've spoken to who still are employees of Purplebricks are concerned that once their names come out in this action, they'll suffer a detriment in their employment. Well, you can forget that, because that's not going to happen. It's strictly illegal. You'll be straight down the tribunal, because it's victimization for asserting a statutory right. And one thing, I was mentioning P&O ferries before, Purplebricks and anyone else will not want to do is to be seen to attempt to be vindictive to their workers. One, they will fail because it's automatically unfair and gives a rise to another claim to the employment tribunal. And 2, it's really, really bad.
Yeah. And the other thing that I heard, I was talking to a former Purplebricks worker, and they were concerned that apparently there is a clause within previous contracts, so the contract that exists between Purplebricks and the LPE formerly, that states that Purplebricks are protected. So even if they're in the wrong and someone takes them to court and that individual wins against Purplebricks, regardless of that, that the legal costs of Purplebricks would have to be paid by the claimant, even if the claimant was in the rights. Now, that sounds bonkers to me, but that does exist in some contracts.
It does, and we've seen various types of clauses akin to that. There seem to have been a publishing revolution in Purplebricks.
But do they have merit? Do they have merit?
No, not whatsoever. I mean, the point is, under the common law, that would be completely wrong. Only a court can decide on cost. And for instance, the tribunal, you'll never get costs against you. And so that in itself is wrong. But further than that, I mean, this entire approach of putting clauses in contracts like this to support a company's view has been completely destroyed. In the Uber case I mentioned before, went to the Supreme Court, and Lord Leggett, who was deciding judgment in that, citing cases going back over 20 years, proved that such clauses cannot possibly bite. You are not allowed in this country to write a clause in the contract which is contrary to the legislation, which is there to protect workers. Parliament have decided X, Y, and Z will apply, and you can write what you like in the contract. That's not going to disavow the will of Parliament. So those are really very heavy-handed. And as you say, as a layperson, you notice this, very prescriptive clauses cannot possibly legally bite. And I know people have been leaned on because of these, and some people have refrained, and other people were going to refrain from taking legal action until we'd spoken to them. But there's no need to be concerned about any of that, because it's completely illegal, and it could never possibly affect anyone.
So you can sit there as a former LPE of Purplebricks, looking at that contract, looking at that clause in that contract, and saying is it's unlawful. That contract.
Absolutely. There's no way that could ever bite. And it's just, this isn't just to smear Purplebricks badly. Very often, as an employment law as I am, clients will ask you to write these things into their contract. If you say, well, actually, it is completely illegal, it will have no effect. It might frighten people a bit, but as soon as they go and get some legal advice, they will know your lies. There's no point. But sometimes people put it in, it's in there to frighten people. It can have no possible effect.
Right. Well, look, Aidan, we've covered a lot of ground, I think. So we've confirmed what the action is all about, the enormity of it in terms of the potential claim, both in total and where individuals are concerned. We talked about the kind of the false pitfalls, the false obstacles, I suppose, where potential claimants are concerned. And what you're saying is that the primary reasons potentially for not jumping on this action really aren't valid. People shouldn't worry about that. And the fact that, notwithstanding the legal process, things are moving. This is going to come to conclusion one way or the other, whether it goes to court or whether it's settled early. But the message surely has to be that people should get involved and sign up while they can.
I mean, I think that's right. I mean, chances like this, where the legal field is already set out effectively, don't come along all that often. And if people think, or they don't want to be something that seems like a money grabbing venture, it's not. These are sums which should have been paid to these people. They are due to these people.
So they're entitled.
Yes, exactly. It's what you should have already had. And so joining on this as quickly as you can, be part of it, you will get that. And you will also get the High Court interest on it, which dates back to when you should have had it in the first place.
And a question that might be one for an accountant rather than a legal question, but will someone have to pay tax on that award?
Depends upon what it's paid for. Usually in awards from the court, no tax is paid. There are various side issues and things where sometimes they are. But for instance, it's generally common in employment cases when you get an award. If, for instance, you've lost your job and you've been receiving universal credit, something like that might be deducted from it. But usually the award isn't taxed, or it's not taxed below a certain amount. And in usual employment settlements, that's £30,000 or £40,000, and things above that may be taxed. But it depends. The revenue has a discretion, but it's very seldom, if ever, used in court awards.
That's good to know. And just before we finish, I just want to go back on one thing that we talked about. I should have done a follow-up about 10 minutes ago on this, but it's just come back into my head, so apologies. Talked about the information that is required now from those agents that have signed up, particularly invoices, bank statements, and so on. If those things can't be found, or if those things, I don't know, maybe the agent's worried because they're a little bit kind of sensitive. You mentioned there's a mechanism in terms of Contractors for Justice maybe being able to help by serving an order on Purplebricks for Purplebricks actually to come up with that information.
Yeah, I mean, that's right. I mean, if people can't find this information, then Purplebricks certainly have the information. Purplebricks will have everything from when that first individual applied for a job all the way through every payments they receive and things, and they have to retain that under data protection legislation. And so either the individual or we are doing this en masse for people with their permission. If they sign permission for us to do it, can simply send a data subject access request to Purplebricks and say, I am X, I work for these periods, I want everything you've got on me. Purplebricks then have 30 days to respond to that, and if they don't, they'll be referred to the Information Commissioner, who will then ultimately punish them for not producing that information. So you are entitled to any personal information anyone holds on you. And in this case, that means everything from your first tentative phone call or email to the signed contract you did to your invoices, do everything.
Got it. Well, look, this is all, I think, pretty straightforward. So look, thank you very, very much for talking to me and for clarifying where the Contractors for Justice claim is. And I guess the message is, look, go to the Contractors for Justice website, C4J.org/estate agents. And just register your interest if you haven't already. And I think they also have a team of call handlers. So if you're still unclear or concerned, I suppose, in terms of anything that we've spoken about, or indeed anything that we've missed, then obviously as a potential claimant, you can speak to Contractors for Justice on the phone and get that clarification. Aidan, thank you very, very much indeed. And maybe we'll do this again as things continue to progress, but thanks for joining.
By all means, it's been a pleasure, and thank you. It's been a good opportunity to hopefully put some of those concerns to rest. So thank you very much.
Pleasure. Thank you.